All right, if there's nothing further then to take up at this time, is the defense ready to make your argument?
Yes, Your Honor. May I begin, Your Honor? Good afternoon, Your Honor. Once again, my name is Tariq Barnett. Today, the defense's pretrial motion will argue that the acquisition of the GPS location information from Mr. Casey Davidson's personal car is a violation of the Fourth Amendment's protections against searches and seizures. In addition to this, is the holding of the defense that the third-party doctrine, the United States legal theory, which states that people who voluntarily give over information to third-party companies and therefore do not have a reasonable expectation of privacy, does not apply here today because the defendant, Casey Davidson, did not give over his information voluntarily and has a reasonable expectation of privacy regarding modern technology that society should deem acceptable. Your Honor, today's digital devices that people possess contains more information than they know about. The 2014 Supreme Court case, Riley versus California, bears a striking resemblance to the case at bar. In that case, the court determined that information on these devices could expose to the government far more than the most extensive search of a house, as these devices create a digital record of people's lives. Your Honor, the prosecution seeks to commandeer the GPS location data from Mr. Casey Davidson's personal car without a warrant. The only justification for the seizure is a court order pursuant to the Stored Communications Act obtained by Detective Adrian Carroll. Riley further established that when privacy-related matters are weighty, a search may require a warrant.
Let me just ask a question. Couldn't the police have just done it in the old-fashioned way and trailed them? And wouldn't it be the same, pretty much the same type of potential privacy invasion?
Well, Your Honor, if I believe that is the case for the United States Supreme Court case, United States versus Knotts, in which the police followed a suspect on public highways, thoroughfares, and roads, and the court determined in that case that the police officer could have received the same amount of information if he had just followed them. Unlike that case, the case at bar with Mr. Casey Davidson, with the information that Detective Carroll received, that information shows where he's been on private property and as well as public roads.
Okay, thank you.
May I continue, Your Honor?
Yes, please.
Your Honor, due to the copious amount of information that is stored within it, it is reasonable that this search should require a warrant. Otherwise, it constitutes a search under the Fourth Amendment. Your Honor, the prosecution will argue that Mr. Davidson had no reasonable expectation of privacy regarding his own personal GPS location information. We can determine if Mr. Davidson had an actual expectation of privacy based on the holding in the 1967 Supreme Court case, Cass versus the United States. In that case, Justice Harlan stated that a person has a reasonable expectation of privacy if they meet two of the following criteria. One, that expectation is subjective. Two, that expectation be reasonable to society. Your Honor, Mr. Davidson meets both of these criteria and therefore has a reasonable expectation of privacy as it is the data from his own personal car. And similar to the police officer in Katz, Detective Carroll, did not receive a warrant to seize this information. Only the court ruled it as a search in Katz. The 2015 case, in reapplication for criminal investigations needed for telephone information needed for a criminal investigation, concerns the government trying to access petitioner's historical cell site information, which includes the physical locations of the cell tower and the certain sector of the tower that the phone is connected to. The judge in that case denied the court order for this information, holding that this request falls outside of the third-party doctrine. Now, Your Honor, while this case is not binding, its relevance is important today to show that similar to the consumers in that case, Mr. Davidson had a reasonable expectation of privacy as it is the data from his own personal car. Your Honor, based on the information that has been provided for the court today, Mr. Davidson's reasonable expectation of privacy regarding the GPS location information of his own personal car is legitimate, and the acquisition of said data constitutes a search under the Fourth Amendment. Thus, the defense respectfully asks that you find the data inadmissible in court today. Thank you.
People?
Yes, Your Honor. I'll also be using Exhibit J during my argument. Would you like me to pass up a copy?
That's all right, thank you.
Of course. May it please the court? The people request that you deny the defense's motion to suppress the GPS evidence obtained in today's case on the grounds that that information was obtained pursuant to the Stored Communications Act, which authorizes the disclosure of such information, and because the defendant had no reasonable expectation of privacy in the information that was being sought. During the course of the Alex Thompson homicide investigation, the police received a tip that placed the defendant's vehicle in the vicinity of Mr. Thompson's home on several dates leading up to his murder. Pursuant to the Stored Communications Act, the third-party service provider of such GPS coordinates turned over records that did confirm the defendant's vehicle was in fact outside of the victim's home on several days leading up to his death. Those records are the subject of the defense's motion to suppress in today's case. Under the Stored Communications Act, the third-party service providers of remote computing services are required to turn over information that reveals the defendant's location only when it is reasonable to believe that those records are relevant and material for an ongoing criminal investigation. Your Honor, in today's case, there's simply no doubt that the information obtained met that standard. The crux of the defendant's argument is that he had a reasonable expectation of privacy in the information being sought, and that a search warrant was required in order to secure the release of such information. Your Honor, the defendant is wrong on both of those counts. First, the defendant had no reasonable expectation of privacy in the information being sought. This is because he voluntarily transmitted this information to a third party, and by doing so, he assumed the risk that any of that information could be turned over to the authorities. The third-party doctrine is outlined in the cases of Smith v. Maryland, as well as the case of United States v. Miller. In both of those cases, 100% of the information was being held in the possession of a third party.
This case seems, our case that is, seems factually very similar to the situation of U.S. versus Jones. Could you distinguish them?
Absolutely, Your Honor, and that's a compelling point. In Jones, the authorities exceeded the scope of a warrant that was placed, and they trespassed on the defendant's vehicle. Here, there was no trespass in today's case, and the defendant was voluntarily transmitting his information to a third-party service provider. May I proceed?
Yes, please.
In the cases of Miller and Smith, the court reasoned that the defendant had no reasonable expectation of privacy in the information being sought because they voluntarily transmitted the information to a third party, and by doing so, they assumed the risk that that information could be turned over to the authorities. However, even more recently, the federal circuit courts in our closed library in the 3rd, 4th, 5th, and 11th districts have all held that the disclosure of cell site location information is not protected under the Fourth Amendment. The same is true here. The defendant was voluntarily transmitting his information to a GPS service provider, and the defendant never had direct control over the records that were being obtained. At no point in this entire criminal investigation did the authorities ever seize this information directly from the defendant's vehicle. Simply put, he had no interest in the records that were being sought. However, even if you do find that the defendant did have a reasonable expectation of privacy in the information being sought, all of that information places the defendant on a public thoroughfare or a public road. In the case of Knotts v. United States, the court held that any information placing the defendant on a public thoroughfare is not protected under the Fourth Amendment because that same information could be observed via visual surveillance. The same is true here. In Exhibit J, all of the information we see on the 12 locations that places the defendant is placing him on public thoroughfares or public roads. None of the information we have places the defendant in a traditionally protected area, such as his garage or his home. If the defendant was in a traditionally protected area, he would have a reasonable expectation of privacy. However, once he enters a public thoroughfare, his reasonable expectation of privacy is compromised, if not completely diminished. Your Honor, because the defendant had no reasonable expectation of privacy in the information that was being sought in today's case, and because the information was obtained pursuant to the Stored Communications Act, we request that you deny the defense's motion.
Stop. Time has
Thank you.
expired.
Any rebuttal?
Yes, Your Honor. May I begin, Your Honor?
Please.
Your Honor, a salient argument in opposing counsel's statement is that Mr. Davidson voluntarily conveyed his GPS location information with the third-party company. In order to advance his argument, he utilized the Supreme Court cases Smith versus Maryland and United States versus Miller. But in those cases, the defendants in both cases actually voluntarily conveyed information. In the case of U.S. versus Miller, the defendant knowingly gave over bank slips, deposits to the bank. These are not private communications. These are negotiable instruments used in business transactions. whereas in Smith versus Maryland, the defendant knowingly dialed in those numbers into the phone. Your Honor, far from being a formalistic rule, the third-party doctrine is just simply one factor in the overall analysis for reasonable expectation of privacy for someone. A factor that can be overcome when highly sensitive information is at stake, such as it is today. That is why, Your Honor, the defense respectfully implores you that you find the data inadmissible in court today. Thank you.
Do the people have a rebuttal?
Yes, Your Honor. May I proceed? I'd like to start by addressing an issue that was very prominent in opposing counsel's principal argument, and that was the issue of a voluntary transmission. It's the people's reading that the defendant needs to have some sort of receipt or something that tells him that he knows he's voluntarily transmitting this information. However, Your Honor, that's simply not reasonable. It's not reasonable to assume that whenever Mr. Davidson gets to his car, he thinks that this never-ending amount of GPS information is being stored locally. It has to come from somewhere, and it has to be stored somewhere. For that reason, the defendant has no reasonable expectation of privacy in the information because he's voluntarily transmitting it to a third party, and that's being stored. I'd also like to address the case that opposing counsel cited, and that's Riley v. California. That case is distinguishable on a few levels. There, the information was obtained subsequent to an arrest, and the information seized was from a cell phone. A cell phone is highly more intrusive than the mere GPS coordinates that we're using in today's case. A cell phone in that case was obtaining videos, text messages, phone calls, and that information connected him to a series of robberies that have occurred in the recent past. Here, all we're using is the mere GPS coordinates that places the defendant's vehicle outside of the victim's home. Your Honor, I'd also like to highlight the case of Knotts v. United States. It's the people's reading that the defense believes that there was no visual surveillance in today's case. Therefore, Mr. Davidson has no reasonable expectation, or has a reasonable expectation of privacy while on public thoroughfares. Your Honor, the information in today's case was visually surveyed. Morgan Bonderman, a witness in today's case, will testify that he saw the defendant's vehicle outside of the victim's home late at night. If there was no visual surveillance in today's case, there wouldn't even be a motion to suppress. In today's case, there was visual surveillance, and the defendant had no reasonable expectation of privacy. We request that you deny the defense's motion. Thank you.
Well, thank you both. It was you both raised really good points. It's a tough call, really. And when you read the authorities, they seem to, at least initially, go in all directions, both directions. And there must be a clear thread, or it must be an answer to what these authorities actually sum up to. And the physical intrusion was it was required in trespassing on property and so on. That was the criteria for early warrants. And you look at some of these scholars back in history, William Blackstone and people that have written about the evolution of the law, and they talk about these things, the curtilage, the house and the barn and the hedged area around the house. That was what was sacrosanct. And then years went by, and then things like a telephone was invented, and we started challenging the issue of just the physical trespass type of criteria for ruling on what is a search and what is not a search. And it became obvious that what people said on the phone, and then later what people kept on their smartphones, which they'd normally keep on a desk, and now it's all on a phone they're carrying around with them, are certainly entitled to the same privacy that would have been given to a person back in their home in the early days. So, and you have cases like Katz coming along, and Katz versus the United States, saying it's really the reasonable expectation of privacy that the Fourth Amendment protects more than simply places. And I think Justice Harlan really sums it up well in the Katz case, where he says that first, the person has to exhibit an actual subjective expectation of privacy, and then that expectation must be one that society is prepared to recognize as reasonable. And that's really the issue here, that second prong. And then in the case of Riley versus California, it stated that privacy-related concerns are weighty enough. When they're weighty enough, a search may require a warrant. And really what this, the facts of this case amount to is that the expectation of privacy is simply not weighty enough. When you're talking about GPS coordinates from a provider, it really differs very little from what could laboriously be done manually by simply trailing the individual. The Stored Communications Act gives some privacy to the individual. It's not something that the government can just simply get without any effort. They have to go to a judge and get an order, and there are reasonable requirements for that. So what the courts are saying is that there is no search in this case that requires a search warrant. I think that's the summation of what all the authorities stand for. So with that being the case, I'll have to deny the defense motion. Thank you. Thank you.
Thank you, Your Honor. May we have a moment to set up?
Certainly.
Thank you, Your Honor.